I'd like to start the second half of the panel. So, about the use of expert knowledge, we'll have a 10-minute presentation from each country. First is Japan. Judge Kobayashi, please. So, use of expert knowledge in civil litigation. I'll talk about the system in Japan, how it's practiced. So in Japan, for specialized litigation that requires expert knowledge for trial and judgment, the expert testimony system, the conciliation system, the technical advisor system, and the judicial research official system are utilized. First, I explain about the expert testimony and conciliation, and then judicial research official and technical advisor systems, which are often used in patent litigation. And finally, I explain the explanatory sessions where technical advisors are utilized. Expert testimony is a procedure of examining evidence by requesting an opinion from an expert in the field and using that as evidence. In medical lawsuits, for example, it's required to judge the appropriateness of a doctor's diagnosis or procedure in light of the medical standards at the time, and as a precondition for such judgment, expert testimony is often used together with the technical advisors to be discussed later. Also, there are lawsuits in which the lessor requests an increase in the rent of a building or land, claiming that the current rent is not appropriate, or conversely, the lessee requests a decrease in the rent. In such lawsuits, an appraisal is usually conducted by a nationally certified real estate appraiser as the expert who is asked to give an opinion on the appropriate amount of rent. Next, conciliation is a procedure in which a conciliation board consisting of 3 members, including a judge, listens to the opinions of both parties and tries to resolve the dispute by agreement. It's a method of civil dispute resolution along with litigation. For example, conciliation is often used in cases where construction defects are alleged and disputed. As mentioned, conciliation is conducted by a conciliation board, and by having a qualified architect as a member of the board, it is possible to take into account his or her expertise in the field of architecture and to resolve the dispute in a flexible manner. The inclusion of experts as conciliator is also widely used in domestic proceedings where the value of property is disputed in inheritance cases, for example, and in IP cases. The IP divisions of Tokyo and Osaka district courts started new operation of IP conciliation in October 2019. In civil lawsuits, judgments are rendered in open court on the basis of a written judgment. In the judgment document, the main text, which shows the conclusion of the court's judgment, is presented first, and it has 2 major parts: the arguments of the parties and the judgment of the court on those arguments. The structure of the written judgment reflects the fact that litigation is conducted in 2 major steps or processes. Please turn to the slide. To explain the process from the viewpoint of the court, there's 1, the process of accurately understanding the arguments of the parties, confirming the judgment and evidence structure that leads to the conclusion and defining the issues to be decided, and then 2, the process of making a judgment on the issues. In the first process, the judge reads the written arguments submitted by the parties and receives oral explanations. At the time, the judge examines the contents of the arguments by comparing them with the arguments of the other party and the documentary evidence, while considering what the party really wants to say and how to explain the reasons for the decision in order to respond to what they want to say. In the process of arranging issues, if the process of arranging issues is sufficiently conducted, it will become possible to present a logical and persuasive judgment that is in line with the actual situation of the dispute. In order to accurately arrange the issues, understand what the parties are trying to say, and accurately determine the issues to be judged, takes a good deal of experience for any case, but in IP litigation, especially patent litigation, there's particular difficulty because the issues are related to specialized technology. So, as I'll describe, judges are supported by the expertise of both the Judicial Research Official System and the Technical Advisors System, and I believe that both systems function organically and effectively. A judicial research official is a full-time court employee who is assigned by the judge to investigate technical matters necessary for the trial and judicial review of cases relating to patent and other rights. They are assigned from JPO examiners, trial examiners, and patent attorneys, and in the case of the IP High Court, a total of 11 judicial research officials are assigned, and they are in charge of cases in the fields of mechanics, chemistry, and electricity. At the IP High Court, in principle, judicial research officials are involved in all patent and utility model right trial decision, revocation litigation, and infringement litigation. They're also involved in other cases as becomes necessary for cases that require judgment on technical matters. When explanatory sessions are held, which I'll explain later, judicial research officials are also present and ask questions to the parties. A technical advisor is a part-time court employee who is involved in a case to provide explanations based on his or her experience when necessary, to clarify the relationship between the parties or to ensure the smooth progress of the proceedings. At the IP High Court, with the cooperation of various fields such as academic societies, 200 expert advisors have been appointed from university professors, researchers of research institutes, corporate engineers, patent attorneys, and others. The breakdown is shown on the graph. The expert advisors belong to 3 courts, including the Tokyo and Osaka district courts. The IP High Court usually appoints several expert advisors with different backgrounds in order to obtain expert knowledge from various viewpoints and perspectives. Lastly, as a method of involvement of technical advisors in patent litigation, an explanatory session is usually held on the date for oral argument or the date for preparatory proceedings after the claims and presentations of evidence have been made by both parties. In IP cases, there are cases involving a wide range of technologies, and where cutting-edge technologies are in dispute, there are technical fields that the JPO and judicial research officials are not familiar with, and there are cases where you want to use technical advisors and their knowledge who have actually developed or researched that technology. In addition, even if the case does not involve the most advanced technology, since the time of filing is the standard time for judging the validity of a patent and the term of duration of a patent right is 20 years from time of filing, there are cases where the knowledge of a technical advisor is sought to understand the background of such as the level of technology at the time of filing, the status of product development from then to present, and the direction of future development. We believe that the involvement of the technical advisors will deepen the judge's understanding of the technology on which the judgment is based and allows multifaceted examination of the parties' arguments and their technical positioning, thereby enhancing the credibility of the court's decisions. As you saw in today's mock trial, for the explanatory sessions, we asked both parties to briefly explain their respective arguments using PowerPoint or other materials. And this has the effect of compactly summarizing the main points of arguments, which tend to be long and complicated when presented in writing. In addition, as COVID was spreading, there were concerns that it would be difficult for the technical advisors to come to the court, but in such a case, explanatory session by means of web conference is accepted. That is my presentation about the explanatory sessions. We do not necessarily believe that the current method is the only way for the technical advisors to be involved in patent litigation. We want to be flexible and ingenious in improving the hearings. I explained the system and its practice in Japan regarding the use of expert knowledge in civil litigation.
Next, from China, Judge Liu Could you please explain the situation regarding use of expert knowledge in your country?
In China, to better help judges understand expert knowledge more clearly in the trials, the Article 76 through 78 of the Civil Procedure Law of China has stipulated the expert opinion system, and the Article 79 of the Civil Procedure Law of China stipulates the system of person with specialized expertise. Also, we have the relevant judicial interpretation by the Supreme People's Court. It stipulates the technical expert system. Aside from these systems, there is another more important system we call the technical investigation officer system. Next, I will make an introduction to this system. In order to regulate the participation of technical investigation officers, we also call them the technical investigators in IP litigation activities. The Supreme People's Court of China has issued some provisions on it, which constitute the basic and major regulations to get the court in China to appoint the technical investigator to participate in IP litigation activities. When the court hears patents, new plant varieties, integrated circuit layout designs, technical secrets, computer software, monopoly, and other professional IP cases, it may appoint the technical investigator to participate in litigation activities. The IP court can set up a technical investigation office, which is responsible for the daily management of the technical investigators and assigns technical investigators to participate in the IP case activities and provides technical survey opinions. The technical investigations can be regarded as employees of the court. The main function of them is to help the collegial panel understand the specialized technical matters and to further improve the reliability of the judgment in various technical fields. Compared with other systems above, the technical investigators' opinions are much more important, I have said, because they don't represent any party. They give the opinions from a fair neutral standpoint to the court. In Beijing IP Court, we have the full-time technical investigators and the part-time investigators. The full-time technical investigators are personnel from relevant administration of department and other departments. They may serve as technical investigators in IP court for 1 or 2 years. The part-time investigators who meet the qualification may serve as they are upon recommendation by relevant associations and institutions. The part-time technical investigators are usually selected from the technical personnel in related such as the industrial associations, universities, scientific research institutions, enterprises, etc. In general, the technical investigators shall have the bachelor degree or above and should have the relevant professional technical qualifications and should have at least 5 years of working experiences in the relevant technical field. As to the status, okay, next slide, sorry. As to the status of the technical investigators, they are judicial assistants. When the technical investigators involved in a certain case, the court will notify the parties within 3 days and inform the parties that they have the right to apply for the technical investigators' withdrawal. The withdrawal of the technical investigators shall refer to the applicable applications of the civil procedural law, the administrative procedure law, and criminal procedure law, and the other related personnel with measures. A technical investigator shall perform following duties on the technical issues involving the case, make suggestions on the focus of the controversy, on technical facts, and the scope, the order, and the methods of the investigation, participate in investigation, evidence collection, inspection, and preservation, participate in inquiries, hearings, pre-trial meetings, and trial sessions, put forward technical survey opinions, assist judges in organizing appraisers and other professionals in the related technical fields to provide opinions, attend the deliberation of the cases, and other relevant complete other related work. When technical investigators participate in investigation and evidence collection, inspection, and preservation, they shall consult relevant technical materials in advance and make suggestions on the methods, procedures, and the precautions of the investigation, evidence collection, inspection, and preservation. When the technical investigator participates in the inquiry, hearing, pre-courting meetings, and trial proceedings with the consent of the judge, he can ask the parties and other litigation participants about technical issues. The seat of the technical investigator in the courtroom is on the left side of the judge assistant, and the seat of the clerk is on the right side of the judge assistant. The technical investigators in China shall provide technical survey opinions on the technical issues before the case is deliberated. When technical investigators attend the case deliberation, his opinions shall be recorded in the deliberation record and signed by him. The technical survey opinions is independently issued and signed by the technical investigator and will not be disclosed to the public. The technical investigator has no right to vote on the result of the IP case judgment. The technical survey opinion put forward by the technical investigator may be used as a reference for the collegiate panel to determine the technical facts. The collegiate panel is responsible for the determination of the technical facts in accordance with the law. If the technical investigator participates in the litigation activity of IP cases, she also should sign his name on the judgment document. The signature of the technical investigator is under the signature of the judge assistant and above that of the clerk. If necessary, the People's Court at higher levels may dispatch or appoint technical investigators from the court at all levels within its jurisdiction. If needed, the court may apply to the higher People's Court to dispatch technical investigators to participate in the litigation activities when trying the cases involve the complicated technical issues. If a technical investigator violates laws or relevant regulation related to trial work, such as embezzles, accepts bribes, engaging in malpractices for personal gains, and deliberately issues false, misleading technical survey opinions or untrue technical survey opinions with major omissions, she shall be investigated for legal responsibility. If a crime is constituted, she shall bear criminal responsibility. That's all of my speech about this. Thank you for listening. Thank you.
Thank you, Judge Liu. Next, from Korea, Judge Kim, could you please explain the situation in your country?
Thank you for allowing me to speak on litigation and to use expert knowledge on litigation. The content of my slide shows the five systems. I will explain one by one. Slide page 3. First is judicial and technical examiners. The Patent Court of Korea has technical examiners according to the court organization. In addition, the Patent Court and other courts require specialized examination on intellectual property rights and a judicial research officer. As of the first day, September 2021, there were 17 technical examiners at Patent Court. Judicial research officers are in court, 6 at the Patent Court, and 11 are in the Seoul Central District Court. Slide 4. This case is filed and assigned. Technical examiner and judicial research officer are technical review. Or technical examiner or judicial research officer are designated. They must submit a technical report explaining the technology at issue or opinion issue before the trial date. It is desirable that the judicial panel clarify and specify the issue subject to review of the technical examiner or judicial research officer before requesting their engagement. Additional technical reports may be requested at the first trial date. After submission of the technical report, judicial panel, technical examiner, or judicial research officer gather in for the trial date or the trial hearing date to have thorough discussion examining the technical based on the technical report. The discussion typically lasts for about an hour. This meeting is internally held and undisclosed to the party. It is distinguished from the technical review session, where the parties present the technical issue during the oral hearing. Technical examiner or judicial research officer submits their final opinion in writing on a issue before the court of the judgment. Next slide. As you can see from this slide, we also use technical advisor. This is a system designed for patient hearing and prompt resolution of this dispute by listening to the based on professional knowledge and of experts outside the court, whose specialized knowledge is essential for cases related to intellectual property rights, architecture, medical care, environment, and many others. Next slide. As of the first day, September 2021, there is 657 candidates are enrolled in the patent court, having eyes in patent technology such as machinery, electricity, electronics, telecommunication, construction, agriculture, and forest chemistry. In order to clarify the parties' relations or to proceed with litigation procedure, the court may designate the technical advice ex officio or open the request of parties and let them participate in litigation procedure. In some litigation that requires professional knowledge, technical advice can submit their information or opinion paper or present oral explanation or opinions in the court during the litigation. Technical advisor may directly question persons related to the litigation, such as parties, witness, narrator, the approval of the presiding judge. Part 6, take part in deliberation process of the judicial panel. In practice, the technical advisor system is sometimes utilized ex officio or upon the request of a party. If there is no technical examiner or judicial research officer of the patent court, who is well versed in testing technical pieces, or if the technical content is particularly complex. Next slide. The technical advice system can be utilized separately from technical examiners or judicial research officers. The technical advice can be designated while a new case or can be designated during the proceeding of hearing. Designation advice based on opinions of parties, judicial research officers will have to expert who fit the case. Next slide. These slides show how expert witness system is utilized. Litigation, intellectual property litigation are proceeding pursuant to the civil procedure. Expert testimony follows the usual expert selection. The witness is the process according to the general principle of civil procedure. In practice, infringement litigation of patents and the party often wants to reduce expert testimony to judge several persons having other skill in the time of filing. The defense of prior art, composition analysis, and the comparison of the products, the creation of genuine and reasonable royalty. Next slide. Lastly, the parties' active engagement in technical exploratory session. So it is not solely rely on internal technical expertise. During the technical exploratory session, procedure in which the parties, the counselors are allowed to give an in-depth explanation of the technology at issue for the date of trial or trial, and they often use a computer or visual printer. We recommend that materials for oral arguments for technical explanations return his support at the date of trial, and by adding the materials to the court report, they are classified as exception materials. Through the technical exploratory session, the judicial panel has to understand the contents of the technology issue, the main argument, and the summary of evidence, and the opportunity to directly ask questions and resolve any doubt. On the date of technical exploratory session, judge can understand the technology more clear compared to written explanation or simple verbal explanation about the technology, because the parties bring the products related to the case and try to explain or demonstrate the product. Next slide. I'm going to close with a little introduction of the standing members of Technical Advice Committee to Civil Action. In March 2009, standing members of Technical Advice Committee system was established to supervise the process of selecting professional technical advice for civil suits, to improve efficiency in terms of accessibility to technical advisors. As of the first day, September 2021, 14 standing members of Technical Advice are appointed to the Seoul High Court and the Daejeon, Daegu, Busan, Gwangju, and Suwon High Court. The standing members of the Technical Advice Committee are appointed by the Minister of the National Court Administration. session at the cost too, and afraid they cannot engage in any business making without permission from the Minister of Administration. And thank you for the time and interest today.
Thank you, Judge Kim. Well, at times your sound was somewhat choppy, but thanks to your prepared detailed material, we could understand the gist of your presentation. So next from India. So now, Justice Sin, could you please explain the situation in your country?
Thank you very much. In Indian legal system, we have provisions to use experts in the context of criminal and civil cases. The opinion of the expert is treated as a secondary evidence in the matter, but not as a primary evidence. The expert evidence can take place in both the court as a direct examination and as indirect examination. In the Delhi High Court, one of the interesting models of expert evidence is hot tubbing. Hot tubbing is a process in which expert from both sides is called. They are given questions. Both of them have to answer the questions, and the court can ask the questions to each of the experts in front of the other expert. There is a proper procedure prescribed for hot tubbing procedure, and I have just explained that to you. Firstly, the witnesses, the experts prepare written reports which are exchanged, and the experts can meet without the parties or the representative to discuss the report. Then they prepare a joint statement incorporating a summary of the points on which they agree and what they disagree. On the question of disagreement, questions will be asked by the courts to test the expert's opinion. So this whole concept of hot tubbing has been approved by Delhi High Court for patent cases. And this happened in the case of Micromax versus Ericsson, where Ericsson was suing Micromax for standard essential patent infringement. Under Section 45 of the Indian Evidence Act, expert evidence can be called in all civil cases. Section 115, we can rely upon expert evidence of scientific advisors in patent infringement. And Section 293 of the Criminal Procedure Code, we can use experts for criminal cases. Under Section 45 of the Indian Evidence Act, the court can use an expert for an issue of foreign law, an issue related to science or art, or even for handwriting or finger impressions, etc. But for Indian law, we cannot use an expert. The court is expected to know the Indian law. Normally, in Indian courts, in civil litigation, we can use experts for immovable property cases, for example, engineers for purpose of effecting partition between family members, revenue officials for demarcation of land, in construction related and contractual related disputes cases, we can use experts for establishing breach of a contractual obligation. In cyber cases, cyber experts are used for cyber violations. In the case of a person who may die or pass away, for analysis of a will, we can use testamentary experts. Handwriting experts are used in civil disputes, very usually. In the field of medicine, for example, where there is a minor involved for a guardianship, physical, mental illness, etc., medical experts are used. For comparing DNA, we use expert reports. In criminal cases also, we use for ballistic experts for analyzing the criminal issues. And experts can also be used for giving customary usages and religious practices. These are the kinds of experts we can use in general civil litigation. In IPR disputes, court can appoint a independent scientific advisor to assist the court. And for the purpose of the patent infringement, the court can tell an expert to go to the manufacturing facility to see what is the nature of the product, what is the process being used by the defendant or the plaintiff, raw materials and excipients. He can give an opinion on infringement. Scientific advisor can also give an opinion on invalidity after comparing the prior art which the defendant is citing. Who can be an expert? For example, in pharmaceutical patent cases, experts in biochemistry can be an expert. In Roche versus Cipla, a cancer doctor, oncology specialist was an expert. In Merck versus Glenmark, the inventor herself came as an expert. There can be persons who are involved in computation of damages as well, who can be used as experts. In, for example, standard essential patent cases, people who can depose about the process of prescribing standards can be experts. Someone who can map the standard to the patent claims, someone who can analyze the patents and map the defendant's product to the patent claims directly or indirectly. In order to establish FRAND rates, people in the field of economics and who can analyze license agreements can also be experts. Experts can also be used for fixing reasonable royalty on the strength of the patent portfolio and the license fee commanded in the market. In other technologies, people who are familiar with the regulatory procedures, people who can analyze prior art documents, who can explain working of a patent, manufacturing processes, who can give, relevant industry practice can also be an expert. In trademarks, for example, in disparagement or other kind of cases, advertising professionals can be used as experts. People who conduct market surveys, people who can analyze and give an opinion on damages, etc., can also be experts. In copyrights, for compulsory licensing, people who can analyze license agreements and fixation of royalties can be considered as experts. In authorship or infringement disputes, experts from the broadcasting industry, publishing industry, moral rights are also used as experts in Indian courts. Who can be an expert in India? A person with educational qualifications can be an expert. That is very understood. But even a person with experience can be an expert. In one case, there was a gentleman who did not have an expert qualification, but the court held that if he has experience in the relevant field, he can be an expert even without a qualification in that field. Now, in this, I wanted to show the single judge in this Bringo case. When Bringo was a company which was owning the Nokia portfolio, and ZTE was the defendant in this case. And the single judge held that this Mr. Regis Bates, who was the expert, he had filed the evidence. The court held that he had to have a basic degree in telecommunication. Otherwise, he can't be an expert. But the division bench said, it is accepted and recognized that a person should be an expert with a specialized knowledge by experience. Even then, he can be an expert. So this is a landmark case in India. According to me, in the coming years, we're going to have much more expert use in IPR matters. The patent rules and the intellectual property division rules, which have been notified for stakeholder comments, contemplate filing of claim construction briefs, infringement briefs, and technical primers, where the role of experts is very clearly recognized by the court. So these rules are going to come into effect very shortly. And in the proposed patent rules, a list of experts is going to be maintained by the court. And with the abolition of the intellectual property appellate board, the assessment and the understanding is that there will be more role of experts as we go forward in the future. So if any of these rules are on the website of the Delhi High Court, if there are any stakeholders who wish to give comments, the time is still there to give the comments. And this is all I want to say about expert evidence in India. Thank you.
Thank you, Justice Sin. Well, we have just seen the situation regarding use of expert knowledge in civil litigation in each country. And we observed that in Korea and India, expert witnesses are used more often than technical advisors or scientific advisors, while in Japan, we use technical advisors more. I'd like to ask Judge Kim about this matter. キム裁判官、韓国
Judge Kim in Korea understand that the expert witness is more often utilized. In your presentation, you talked about some example of using expert witness for certain issues. So can you explain the reason why expert witnesses are used more? So in practice, if there is not sufficient knowledge amongst judicial research officers and the technical examiners, then technical advisors are nominated. But in the advanced technology cases, the parties usually bring their expert witness. Then there will be no burden of going through the procedure of using the technical advisors. And so sometimes there's appraisal by dedicated expert organizations. So in practice, the infringement litigation over patent and IP rights, a party often wants to produce expert testimony to analyze the level of a person and also to analyze the structure and compare with infringed products. So you said that in many cases the parties bring the expert witness. So if they want to call different witnesses, how do you decide which expert to call? So it'd be desirable if the parties agree on the expert witness to call. But if they cannot come to an agreement, then each party will select the expert witness and apply. So one may be chosen, and or the plaintiff and defendant may choose multiple number of witnesses.
Tell me how often expert witnesses are used in patent litigations in India?
Expert witnesses are used quite often in India in almost all patent cases. In India, we did not have researchers and technical researchers for the court. But now in the new IPD rules, we are providing for the courts to have techno-legal advisors. So going forward, I think we will have both kinds of experts, both by the parties and by the court also.
Thank you. And so, I would like to ask, how often is the hot tubbing used now?
Hot tubbing has been used in at least 2 to 3 cases recently in the last 1 year. before the COVID happened. And after that, experts have not been able to travel to India. But I think going forward, after the pandemic is over, hot tubbing is a recognized procedure and there will be more cases where it is used.
Thank you. So, again, how about the scientific advisors?
Scientific advisors is more used in patent cases. At least in 30 to 40% of cases, scientific advisors are appointed. And in other cases, parties bring their own experts. Scientific advisors are those who are independently appointed by the court. And the parties can file objections against the report of a scientific advisor also. And therefore, scientific advisors is used sometimes by the courts, but not always.
Thank you very much. Well, it seems that the situation are so different compared with Japan. Mr.
Yes.
Shigetomi. Okay, so, Mr. Shigetomi, how do you think about the possibility of using expert witness in patent litigations in Japan?
Frankly speaking, I recognize that it is very difficult for the party to persuade the court to adopt the expert witness in patent litigation in Japan.
Oh, I agree with you. Yeah. Let's see why in patent litigations in Japan, expert witnesses are seldom used. 小林裁判官、知財訴訟
So, Judge Kobayashi, what's the reason why expert witnesses are rarely used in IP litigation in Japan? So, as I mentioned earlier, it's my understanding that in Japan we have the technical advisor and judicial research official system working well. And so I think there is a unique structure of decisions in IP litigation. So for technology, you have to have the correct understanding. And then based on the legal requirements in the law, you have to make the legal judgment. That is important. And so the expert's opinion is not going to directly impact the decision in a great way. And there are several points. The expert knowledge is relevant for the precondition or the premise of the judgment. And in addition, both parties have reasonable expertise in the technology in question. And I think that's another characteristic.
代理人として
Then, as a counsel, I feel that it would be difficult to admit expert witnesses, but sometimes it is unlikely that the expert witness is accepted. So this is a question to Mr. Kobayashi. So you listen to the cases in the India and the South Korea. So could you tell us a bit about your take on this issue? I think it depends on what to prove with the expert witness. So, as in the case of the situation, opinion is the specification is important. So, based on that, it is possible to make a judgment based on that. However, having said that, sometimes it is suitable for this kind of a system utilizing the witness. So if we receive requests, then in that situation, we'd like to make the decision as to whether it is possible and it is appropriate to use the expert witness. Thank you.
To ask about situation in China, Judge Liu, is it right to understand that in patent litigations in China, expert witnesses are not so often used, while the technical investigation officers are much valued?
Yes, Compared with other systems, the technical investigator officers' opinions are much more important for the judge, because we think they don't represent any party. They give their opinions from a fair, neutral standpoint to the court. Thank you.
Yeah, thank you. Judge Liu has pointed out the significance of impartiality. What we are talking over now can be relevant to profound notion of what is fair in order to reach a fair decision, which we shall put more weight on impartiality or the adversary system. Mr. Hattori, do you have other questions as to use of expert knowledge in civil litigation from the attorney's point of view?
Yes, thank you. Mr. Shigetomi, what Japanese attorneys especially bear in mind when dealing with cases where technical experts are involved?
Yes. Before we ask technical experts to provide their opinion, we always try to explain to technical experts what kind of technical knowledge are really important for the legal issue involved in each particular case. We believe that the technical experts' opinion are meaningful only in case that such opinion elaborates technical knowledge which are directly related to the judge's finding on the issue, whether such technical knowledge satisfies the legal requirement under the patent law. We attorneys should explain the underlying matters to technical experts precisely.
Thank you. Now, we understand that there are considerable differences in the systems and practices in each country regarding how to incorporate expert knowledge into court proceedings. When a cross-border patent infringement lawsuit is pending in multiple countries for same technology by same parties, I assume it is very important for the parties and the attorneys to be aware of the differences in the systems of each country. Mr. Shigetomi, what do you think about this?
Yes, I totally agree with Mr. Hattori's assumption. And the parties and the attorneys should understand the differences of the legal systems in various countries, including China, Korea, and India. Considering such differences, the parties and their local councils in various countries should effectively communicate with each other in order to establish appropriate litigation strategy to prove the issue of infringement and the validity of IP cases.
Have you heard anything from overseas lawyers regarding this point?
Yes, let me provide some practical tips. I heard from the Korean attorney that in Korea, the explanatory sessions are quite important in patent cases. The parties should prepare for explanatory sessions by predicting what kind of questions would be raised by judicial research officers and the technical examiners. Also, although there are not so many cases, with regard to case to which technical advisors are involved in, it is quite important for the party to study technical advisors' dissertations and personality as preparation. As to practice in China, I heard from the Chinese attorney that there is a characteristic procedure in relation to appraisal. In case that the technical issues are complex and there are special requests on method and facility of appraisal, the parties can request the court to hold the explanatory session for the appraisal institution. These practices are different from the Japanese practice.
Thank you very much. Now, I would like to know what judges of China, Korea, and India would like to expect or request the attorneys for each party to do in a patent infringement lawsuit in which judges need to understand technical matters. First, Judge Liu, could you tell me your opinion?
Okay. In China, in some complicated patent cases will welcome the parties' application for expert witnesses to appear in court. If only one party applies for expert witnesses to appear in court, the court will also give the other party the opportunity to provide elaborate explanation of the technical issues. Both parties can provide the expert in witness. They can show the pictures, drawings, videos, etc., so that the court can fully understand the technical issues involved in the case. In this situation, the court will also give full play to the technical investigators by asking the expert witnesses to further ascertain the technical facts with the consent of the judge. Thank you.
Thank you very much. Kim 裁判官
Judge Kim, on that point, when you need understanding of technical matters, what are your expectations or wishes for the counsel? So as mentioned, there are explanatory sessions, and that's very important. In the explanatory sessions, based on the principle of patent law, photos, videos, and the actual things should be used so that the judge can accurately understand technology and the infringed product. Thank you. So to take difficult things, make it easy to understand so that that can be actually accurately understood. That is important, is what you said.
Could you tell me your opinion?
Yes, I think I agree with Justice Kim that in order for judges to be able to understand technical matters, the lawyers should keep the pleadings very, very simple. The language should be simple. Technical reports can be filed with the petition or with the application, which is drafted by experts. And in India, unlike what happens in Japan, courts trust the experts of the parties. And then they decide which expert should be taken, which expert opinion should be accepted by the court than the other. So the credibility, the honesty, and the truthfulness of the expert has a major impact on the judge. Because the court feels that if experts are being put by both the sides and the plaint is drafted in a simple manner and the expert is giving a report, if the expert is cross-examined, if the witness who speaks truthfully will be believed by the court. That is what is the practice in India.
Thank you very much.
So I'd like to ask one additional question to Justice Sin. In your presentation, you mentioned that new rule stipulates about the technical primers. And so could you please tell us the purpose of making a rule of submission of technical primers?
The purpose of a technical primer is to explain to the judge the technology. The technical primer could be in the form of a PowerPoint PPT presentation. It could explain the state of the art which existed when the patent was filed. What is the step in the novelty? What is the inventive step? And how the invention has made a difference in the relevant field of technology. It need not be a long report. It can be in the form of a slide presentation also.
So is it right to understand that one of the purpose of the technical program is to divide technical matters from legal matters? Is my understanding correct?
Absolutely correct.
Thank you very much. Well, it is about time we should wrap up the panel discussion, though we prepared more questions. Now we have much better understanding of current situations regarding indirect infringement and use of expert knowledge in civil litigations in each country. Interestingly enough, even though we do have differences, it has turned out that differences among our countries are not so outstanding as they may seem from legal provisions as to the indirect infringement. On the other hand, as to use of expert knowledge in civil litigations, we have observed more differences in practice than we could see just knowing the existence of legal methods. As a moderator, I would like to thank all the panelists online deeply for your contribution to the panel discussion. それでは以上でパネルディスカッションを終了いたします。
With this, we'd like to close this panel discussion.
ご登壇の皆様、ありがとう。
Thank you, panelists.